My name's Nancy Weaver Teichert, and I started working for the Sacramento Bee in 1985 and left in 1996. I was a general assignment reporter, investigative reporter. I covered social services a lot, and those are the different areas.
I'm Charity Kenyon. I was an attorney in private practice, and I first represented the Sacramento Union, and then when we started representing KOVR, which was a McClatchy television station, we started representing the Sacramento Bee as well. So that would be in the in the mid-'80s, I guess. Yeah.
And she's probably not going to mention it, so I will. Charity was in 2007, she was awarded the prestigious American Inns of Courts for the Ninth Circuit Court of Appeals for her sterling character and unquestioned integrity. She's been listed by Best Lawyers of America as one of the nation's top First Amendment attorneys for many years and top country's top appellate lawyers. And she, for us at the Bee, she was the one that would help us champion First Amendment rights and access to public records and all these important things. And she was just one of those behind-the-scenes persons who helped the public with their right to know.
So, okay, well, I'm retired now, but honestly, all these accolades, it's really because I got to represent people like Nancy and Denny and Sam, who had a pretty special relationship with the courts and were such well-respected and really tenacious reporters. So that's how you get the accolades. You represent people like that.
I think there was a level of trust that the judges had for you and for us as reporters that
Definitely.
was important.
Definitely.
A paper that has been around so long and has established their community reputation helps.
Right. Yes, people outside of Sacramento used to complain that the courts would do anything I asked them to do. Well, not really, but I'd like you to have that impression. So, yeah.
Yeah. Well, I thought I would start first with the case that you helped me on, which was children who were under Child Protective Services, which meant that they were victims of abuse and neglect. And the Child Protective Services was to leave them in their home and make sure that they were not hurt anymore and that their parents were helped to create a safer home. And all those records of course, are confidential because they're children. But there were a number of children who died while they were under CPS care. And so we wanted access to the case files of the children who, while CPS was supposed to be protecting them, they were killed either through abuse or neglect by their parents, to find out what went wrong with the system and answer the questions about how it could be made better for children in the future. And so Charity and I went on a 6-year journey to get access to those records, and we would meet in outside courtroom hallways and sit on benches until we were called, and then we would go into the courtrooms and
it started in 1992.
Yeah. And we would be told all that we were doing, we were going to violate the privacy of children and the families. And the children were dead, and the families, we weren't going to name them. So we didn't understand why this would be a problem, but it took 6 years, and you could explain about the court procedures and where we all went.
Well, we do have, of course, several code sections that protect the privacy of juveniles in juvenile court. But one of them, Section 827, gives the judge some discretion about who he or she is allowed to show records to. So we were kind of pushing the envelope to say that would include the news media when there's a matter of public interest. And we persuaded Judge Tal Jones. The case, he entered an order. He said that he would have a temporary judge look at the documents while Nancy asked him questions, and he could tell them what was in it. And so his authority to make this little unusual rule was challenged in the Court of Appeal. But we won the big part, which was that he did have discretion under 827. News media were included in the people he could show the documents to. The part they didn't like was there would be a temporary judge, who was Judge Morris in England, who was a commissioner at the time. By the time we got through the case, he was a judge. So he ended up being the fellow that actually did look at the documents. And Nancy and I can both remember looking at his face when...
Oh, it was amazing. So I would be in the courtroom with Judge England, and you were there then?
For the very first
okay.
one.
And the judge would have the case files in front of him, and I would ask questions about how often the county social workers went to check on the child, how often reports had been made by doctors, teachers, family members, neighbors that children were being abused, and how many times those reports were neglected and not addressed, and the children then died. And it was moving for both Judge England and myself. He said that he had never seen one of these files from the beginning to the end.
They're this thick, but they usually look at the top layer when it comes.
Yeah.
And he had never gone all the way through. And so here you could see him seeing. It was going to be so obvious this kid was not going to make it through.
Yeah.
But when you just get one sheet of paper at a time.
Yeah, and more than once I went home and cried. And I will tell you a little bit about...
Can I ask you a question?
Mm-hmm.
So just for context, how did you start on this story? What drew you to it? And then can you give us an idea, like the kids were here in Sacramento, or were they in the outlying areas? That would be helpful.
They were in Sacramento County. It was Sacramento County Child Protective Services.
Okay.
And the reason I got involved in this is because social workers who worked for that department were telling me that the focus was on preserving families, and they were trying to offer them services to make them better parents, and so the children could remain in their homes. They were then taking money that they would have spent for foster care and using it for other purposes for the county deficit. So the social workers were very upset, so they were my sources. So in 1992 was when we started to ask for limited access to confidential files of 3 children that had been reported to authorities, and they were under CPS protection when they died. That request was denied. And then in 1998, the files of 2 children were granted under a protective order where I could ask the judge questions. And then finally, in 1999, we were able to ask the judge about questions for 13 children who had died while they were in homes with a history of abuse and neglect. And under CPS protection, they had been killed by their parents. And some of the things that we discovered was just so jarring. And I'll just give you a couple of examples of the things that we were able to access without violating the privacy of any of the siblings or family members. But it was important that people know what happened to these children. One child, 6 months after a doctor reported that the child had been abused, a social worker visited the home 19 times and did nothing. The child was beaten to death 6 months later. A hospital reported to CPS about a child with a broken arm and old burns. No one answered at the door when the social workers went out to inspect the home. The case was closed, and a month later, the child was dead. A father slit a mother's throat in front of the children. When the mother later slashed her own throat during another troubled time of her life, CPS warned only that she might not be, quote, acting appropriately. The child was drowned in a bathtub later. And the most famous case, of course, is one that reporter Cynthia Hubert uncovered, which was, and made such a she wrote such beautiful stories about this child. Adrian Conway, he was a 3-year-old child, and his body, almost from head to toe, his body had been bruised, scarred, burned. And 2 months after county social workers decided he was not in imminent danger, he was dead. When they did the autopsy, he was malnourished. He'd been tied to his bed, burned with cigarettes. It was just horrific. And that was, I think, a real wake-up point for the county and this is what was going on. Reforms were made, and I think that we felt like...
as a consequence of these stories,
Yeah.
yes.
Reforms were made, and I think we contributed to hopefully protecting children from undergoing similar endings.
Right, there
of
was
their
a whole review commission, and
Yeah,
Judge
grand
Walco
jury.
looked over it, and I think I was also struck, and I think the county was persuaded that they didn't have enough resources. But
Yeah.
you met these social workers, they were kids, like 25 years old. And I'm thinking, this 25-year-old's going to go and sort this out on this struggling family. And they got a whole lot of cases. They got a knock on the door, nobody answers. They go to the next one.
Yeah.
And that was what you really saw when it all piled up in a file. You could see time after time.
Yeah.
Something that was persuasive was some cute drawing that was on a wall or something like that. Nobody ever looked in the refrigerator. Nobody was too concerned when they couldn't see. Many times they couldn't get in the house at
Yes.
all.
And one mother wrote a long, lengthy thank you letter to CPS for helping keep her family together, and of course that child ended up dead later.
Yeah.
So,
So I think the role of the Bee in disclosing this, forcing some reforms, and getting more resources to the department is significant.
and at the same time, we did not violate anybody's privacy, and I think the courts knew that both Charity and the Bee were going to act responsibly in terms of what to do with this information, that nobody was upset or hurt after. When the stories came out, nobody claimed that their privacy had been violated in any
Right.
way.
So you never publish names?
Well, only of the children who had their criminal charges brought against a parent. Otherwise, we did not publish their names, no.
So the children that died, you never published their
No.
names?
Well, like Julian Conway, because
The mother was charged with
Right.
murder.
Okay.
But in these other cases, there were never any criminal charges brought against the parents that we could find, so we didn't use the names.
But there were never, ever any criminal charges even after these things
Not
came out?
that I.
some of them are pretty amazing.
Yeah.
I can't remember the name of that one case where this child completely disappeared. They never have found the child. And the mother has never been charged.
Yeah,
That's very strange.
I know.
So
I should have pursued that. I should
Yeah.
have pursued the lack of, but I didn't have the names unless there were.
Yeah.
That's another case. So you can't get the names. If you can't get the names of the children, you can't find out if their parents were charged. So you
But
can't
what-
look at the record of prosecutions.
So, did you look at, did you, so I hate,
Mm-hmm.
I hate to ask this question, but do we know if these were families of color? And did that play into this at all?
I have no idea. I did not.
So we never will know that.
Well, Justin clearly wasn't. I think, yeah.
Adrian Conway was.
Adrian Conway, no,
was
was
a
not.
white child,
Yeah.
Caucasian. Yeah.
No, I don't think that.
Drugs was more of an issue too.
Yeah.
That they decided that they would work with families who were on drugs, and to try to keep the kids in the home. And meth was a terribly dangerous drug at that time, and there was quite a bit of meth abuse. And I think that played a big role.
Yeah.
in,
I don't think it was people of color so much as the meth.
Yeah, I think it was drugs, and the
Epidemic.
desire to leave. They want the idea that saving the family.
And
We've got
family
priority.
reunification is, on its face, it's a good idea if you can do it. You don't want to yank children out. For one thing, as we also learned, the foster families can inflict a lot of hurt as well.
Yeah.
And kill kids and disappear kids. So family reunification is, it's a good policy, but it requires a lot of resources and a lot of follow through and a lot of skepticism. And we weren't finding that.
Yeah, one of the points that we made that I thought was, and the lead that was so good, which is that children don't tell, mothers lie, social workers are deceived, and policies designed to keep families together had failed. And that was a very important thing for the public and voters to know, and the county officials to know. And they took steps then to address that.
What kind of steps did they take?
They increased their budget for social workers so that if you had one social worker juggling 30 cases, you would have, they hired more staff. They did more training. They changed their name from family preservation to child protection. They changed it to family preservation. And so they started putting more emphasis on making sure these children were safe in those homes if they were going to leave them there and try to keep the homes together.
And is any idea today?
There's a child death review team, which was established during this time period. And I think it's still, I haven't checked lately, but I think it was still operating on a yearly basis through the DA's office where all child deaths were reviewed and there would be a report published under what circumstances these children died.
So this story wasn't assigned to you?
No, I found it from the social workers. They told me about what was going on.
And then so you had to get permission to work on this?
Yes.
And was that easy to get, or?
Yes, yeah, it was easy to get because I had enough information, and the Bee was very encouraging of long-term projects if they felt that they were warranted. And
At the time.
at that time, and they would give us months. I think I maybe worked on this, well, obviously 6 years of legal work, but I think I worked on this for at least a year. And the Bee was able to devote that time to investigative reporting, and as we know, they continue to do that, and for many years, and I hope that under new ownership they will continue to do that, because that's the sort of reporting that you cannot get anywhere else. These are the kind of stories that are so important and so crucial, but newspapers have to have the time and the money. Reporters have to have the time, and newspapers have to have the money to let them devote this much effort into one story. It was a series of stories.
Yeah.
So as this was unfolding, how much did the two of you work together on this?
Well, mostly we worked on in connection with the records. Yeah.
I mean, I was writing briefs and going after the court for appeal, that kind of thing. So we'd be in court together, but I wasn't working on this story.
I was talking to unnamed sources.
That's the other thing, anonymous sources, I was going to say, which has got its own.
Oh, yeah. Own risk. You can.
And I didn't want to know the source because if I feel like if I knew, then I could accidentally give a clue, and it might compromise what I'm thinking about the people sitting around me and what we're doing. So many years later,
never asked the name of an anonymous source.
Who was your editor at that time?
During this time, gosh. Well, Gregory Foff was the editor.
Gregory's been in.
Yeah. The Bee has done such a great job of taking these issues and really exploring them, looking in depth and finding these problems that need to be addressed. Another series that I worked on for a long time was Hunger in California. And that was, I thought, was a very important series. And so I think that the Bee has done an amazing job in that area.
How long did you work on Hunger?
Probably 6 months to a year. There were several of us that were working on that. It was statewide.
And were there legal issues with that, or how common is it to work with a lawyer on something like this?
Not very common.
No.
I think the thing I would say is consistent was trying to get access to courts and court proceedings. And that's another place where local news is really critical. The Associated Press and the Washington Post and all that are not going to keep an eye on your federal court or your superior court, and the Sacramento Bee did. And whenever some criminal defendant wanted to close a pretrial hearing, the Sacramento Bee would let us go in there and object and file papers and persuade the court that we had a right to be there on behalf of the press and the public, so that our court proceedings were open. And several of those cases went up to the courts of appeal. And a lot of them, I began to think that some of these were done to draw attention to a case. You didn't really want to keep the press out because you knew you were going to lose, but you had a case like Ellie Nestler up in Tuolumne County, who shot in the courtroom and killed the man accused of abusing her child, which is one reason we have metal detectors going into every courtroom now. Melvin Belli was representing Ellie Nessler, very famous San Francisco attorney. Scott Peterson, 2004, down in Stanislaus County. Mark Garagos was representing him, and and Gloria Allred was there. So I think some of those people, they're just not really thinking they're going to exclude the press. They want to draw the press's attention to the case. Charles Ng and Leonard Lake up in Calaveras County, who had tortured and killed several women, like a dozen, in their underground bunker thing. Tony Serra and Ephraim Margolin, two very famous attorneys. Did you really think that we're going to stay home and not object to your closing the courtroom? They could have had all these proceedings without a whole lot of attention drawn to them, I think. So we were, we would sail in and object, and the court would be open to the press for the benefit of the public. And to the extent, one of the fun stories of Judge Finney up in Placer County, there was a hearing going on, and by chance, another completely unrelated client of mine was in that courtroom, and some criminal defendant's attorney gets up and says he'd like to make a motion to close the courtroom, and Judge Finney looked at him and said, "Don't do that, because then I have to call the Sacramento Bee, and then they'll send Charity Kenyon up, and then she'll persuade me to keep the courtroom open. So why don't you just skip that step?" So I didn't have to even file the papers. But I think that's also a story about how well respected the Bee was for doing that work on behalf of the public, keeping our courtrooms open. Denny Walsh is another person you should really talk to, because he knew everything that was going on in the federal courts. And judges, once he retired, judges say, we'll never know. We, the judges, will never know as much as we knew when Denny was here about what's going on in our courtroom.
And one of the important things about the pretrial hearings is that if it's later settled or they take a plea or something, there's evidence that comes out in the pretrial hearing that the public wants to know and should know. And that wouldn't be told if.
Yeah. Well, a lot of cases in California, that is the proceeding. The preliminary hearing is it, and then there's no trial because they work out some kind of a plea deal. So that was the press enterprise case, United States Supreme Court. I had a case going up at the same time as a press enterprise was objecting to closure of a preliminary hearing. California Supreme Court ruled that under our statute, the preliminary hearing could be closed. They took it up to the United States Supreme Court. At the same time, Judge Leighton Hatch here in Sacramento, municipal court judge, I made a motion to get into a preliminary hearing. So all these First Amendment lawyers are making these same motions. Judge Hatch was great. He just looks at me. He looks, make your motion, state your opposition. Thank you. Courtroom closed. Next. I was like, okay, so I filed the petition for writ of certiorari. United States Supreme Court ordered the opposition to file a response, which is pretty rare, but at the same time, Press Enterprise was making its way up, and so they had the opportunity not just to reverse a Sacramento municipal court judge, but to reverse a decision of the California Supreme Court. But that gave us this First Amendment right of access to preliminary hearings in California, and that was a 1984 and 1986 decisions. So that's what we relied on, those decisions.
And you went to the U.S. Supreme Court twice, was it? Or how many times did you go to the U.S. Supreme Court?
I never made it there all the way.
But you were.
Yeah, I filed and then people withdrew their opposition.
Yeah. And I think one thing, the persistence, the fact that the judges knew you were not going to give up, and so they had to really address the concerns. They couldn't just dismiss it and you would go away.
Or another story, and again, I have to leave out some names here, but a very well-respected judge had closed the hearing, And so I filed a petition for writ of mandate, and 3 justices of the Court of Appeal are walking down the K Street Mall, and, oh, Charity, how's it going? I said, well, it'd be better if you guys would actually read my petitions. Okay, so they went back and read it, and that judge petition was granted, and then I run into him in Tower Books, and he goes, well, Charity sued any judges lately? But my point being that once you, as Nancy said, once you show you're going to follow through, and once the judges say they're going to take it seriously, then the message gets out among the judges. Yeah, this is serious. Let's pay attention. Let's do it right. Nobody likes to be reversed. And then you don't have to file. You don't have to worry about objecting because they're not going to close the hearing. And that was true also in the federal court. They're very aware of the right of public access here in Sacramento.
Well, one of the first stories I did when I came to the Bee was about looking at problems with the old jail, which was needed to be replaced, and they did build a new jail. But after that story was published, we were sued for defamation or libel, I forget which, by the Deputy Sheriff's Association. And Gary Pruitt, who at that point was our First Amendment attorney before he moved up the ranks at McClatchy's paper, but he said, I said, what is this? Why are they doing this? He said, well, in the past, we just give them a few $100s and they go away. And you know what? We're not going to do that anymore. And that, I think, in the 70s and the 80s, started to change, that newspapers were going to stick to their rights, and we're not going to just give in and pay a few $100s to make somebody go away.
Well, we also got the anti-SLAPP motion to strike. Code of Civil Procedure 425.16, and I can't remember, it's 1993, which is SLAPP cases, strategic lawsuits against public participation, where like a developer would sue people objecting to a development, or somebody who stands up at a city council or board of supervisors and objects to, and they'd sue them for defamation, knowing they're not going to win, but the cost of defending yourself was so tremendous that it was a strategic lawsuit against public participation. So keep people quiet and not complaining. And to address that problem, California adopted in 1993, this statute that says if you demonstrate on a motion that what you're being sued for is an exercise of your constitutional or First Amendment rights, then we will dismiss the lawsuit on a motion, there's no discovery, and you will get your attorney's fees paid. So that changed. The defamation and invasion of privacy suits basically went away, because if you were going to sue and we could demonstrate we're doing it's our right of free speech that we're exercising, then they end up paying our attorney's fees. So I had a couple good cases for the Sacramento Bee before 1993, Nicholson versus Superior Court, and Judge Nicholson, now retired Justice Nicholson, Clara Cooper, who was a Sacramento
reporter.
Yes, Sacramento Bee reporter. She got somebody slipped her from the state bar the confidential evaluation of George Nicholson as not being qualified to be a judge. Those evaluations are not supposed to be public, but he was running for Attorney General of California, so Claire it was slipped to her, and she wrote a story, and George Nicholson sued. So I defended successfully, in the Court of Appeal upheld our motion for summary judgment. But in the meantime, under the American rule, we're paying all the attorney's fees. So both on the trial court level and on the Court of Appeal level. So we won, but it still is expensive. And then Fahiza Aleem, I don't know if you've talked to her. She's She's a pretty interesting reporter, retired. She did a story about a California Veterans Affairs Secretary, or whatever, double dipping on his pension and claiming he didn't realize that he couldn't work and receive the full pension at the same time. And I also prevailed on that. So that's 1983. But by the time we get in 1993 this anti-SLAPP motion to strike, none of this would have been anything other than a motion in Superior Court, in the trial court level, and our attorney's fees would have been paid. So that really ended most invasion of privacy and libel actions against newspapers and televisions in California.
But that isn't in every state.
Nope. And it's funny, we in California, we was like, why don't you get this passed? You should. Sure, it puts you out of business, but this is to protect the First Amendment right. Yeah. And it has not caught on. It made a huge difference for us. And this whole idea, that was before my time that anybody slipped a few hundred bucks to somebody. But that explains why you would do it, because otherwise you have to slip a few thousands of dollars on a simple case to somebody to get rid of the case.
And the Bee invested and spent so much money to do all these cases and decided that it was important and they were going to spend the money to do them. And,
yeah, and then it became much easier, of course.
And the shield law was something you mentioned to me that was interesting too.
Oh, right, protecting your...
California had a shield law back in 1935, but then you worked on some of
it protected only sources, but then unpublished information was not clearly protected, so that they could go after a reporter and try to get information beyond what they had published in a story. Brandsburg versus Hayes, United States Supreme Court. Let's see, I can't remember what year that was. Decided that there was no privilege not to testify. 1972. So in response, California in 1974 expanded the shield law so that all unpublished information is covered, as well as sources. And it became then also a part of the California Constitution, Proposition 5 in 1980. So that case I had that went to the California Supreme Court was for KOVR. And it was Ellen Miller was the news director. They had done a video interview of a fellow who was charged with murder. They'd run a portion of it on the news, and then the prosecutor wanted the whole thing without he wanted the outtakes as well, and argued that the California had recently adopted a provision of the California Constitution. We changed our Constitution pretty quickly in California to give the people, the prosecutor, rights to due process. And they argued that meant that we had to, our right to protect outtakes or unpublished information was less than this constitutional right of the prosecutor. But the Supreme Court did not agree. Well, the Court of Appeal here in Sacramento did agree that we had to disclose it, and required that Ellen be held in contempt and sentenced to jail. But we stayed that, and then we took the case up to the California Supreme Court. It was kind of funny because in 1979, representing Sacramento Union, we'd had another shield law case. It was a Mexican mafia case, and of course that's before the Prop 5 in 1980, and we lost that. We took it to the California Supreme Court, but by the time that had wound its way through legal proceedings, they dropped their effort, and John never had to give up his outtakes. So I'm arguing in the Court of Appeal, 1999, or 99. And Judge Puglia, the presiding judge, looks at me, Ms. Kenyon, were you here in 1979 when we ruled against you in the Hammerly case? It's like, yes, Your Honor, and you were too. And then we took it up to the California Supreme Court, and it was unanimously reversed. And the Supreme Court, was one of the last decisions of Justice Mosk, ruled that there was there's absolute right to protect unpublished information in California, just like any other evidentiary privilege. So,
I mean, it's really establishing law. I mean, you weren't just winning these cases for us; you were establishing law.
That's right. Yeah, and even though you don't think of Sacramento as being in the forefront of anything with respect to publication, McClatchy and newspapers was. So where most of my friends who were First Amendment lawyers were in New York or DC or other bigger, or Los Angeles, we were holding our own here as far as the important cases that we were handling and precedents we were setting. And it's because McClatchy was really dedicated to doing that and protecting the rights of the public too.
And California does get a lot of notable cases. You mentioned the Life magazine
Oh yeah,
quote, because we do have a great number of serial killers and
That whole shelf, it's all on serial killers.
really. So I was with Scott Peterson's case, and I remember I was arguing about access, and I was like, Your Honor, the trial of the century happens quite frequently in California. And that Life magazine liked that quote, so there was my trial of the century happens quite frequently in California.
Do you have that magazine?
No, I never did. I found it only by Googling. I didn't even know Life magazine was
They still print.
still in a,
They don't print regularly, but they still print.
yeah. No, I thought it was a nice photograph. I was very surprised that they picked that up. Yeah.
And you were often called by national anchors on news to comment on.
I was telling you about, again, on Scott Peterson, everybody wanted to make it into a media circus, and we're trying to not make it into a media circus. We're trying to tell the court that we can responsibly cover this without turning everything upside down. So Larry King gives me a call. You want to go on this? No, I do not want to go on your. Then Greta Van Sesseren, assistant, calls me. Oh, well, we'd like to have you on our show. I was like, I don't want to be on the show. Pick up. Greta's calling me. It's like, no, what don't you get about this? We're not going to make this into a media circus. And then all these people, Charity, you could have been famous. You could have been on Larry King. Well, actually, that would be, in my opinion, counter to what we were trying to accomplish with these access motions. We're trying to show that we can do this without making a circus out of it.
Which I think is why they were more receptive every time we brought a case, because they knew that the Bee was going to act appropriately and McClatchy was going to act appropriately and you were going to act appropriately. And
oh yeah, that's another one of Denny's cases where the very rare to have a juvenile court proceeding in federal court. So rare that they didn't really know what to do in a case where there was a cross burning up in Redding or that area. And so they had a juvenile, and they're going to have to do stuff. And they started. It was kind of like off docket and in a parallel system, and where they weren't publicly putting the name of this kid in the file. Well, Denny knew that they're about the cross burning and that the feds were going after this hate crime, so he starts. Nosing around in his way, and he figured out who it was that had the case and so on. But we had to pretend that we didn't know because it's all filed in the off docket. So okay, let's be clever. I wrote a letter to the presiding judge. Like, we didn't know where it actually was, but we understand that there's this proceeding going on and it's not on the docket, and which is totally improper. Cite the cases that say you can't have a secret docket. And of course, the presiding judge then, the chief judge, sends it down to the fellow that was the judge, and whoa, wake up call. But the judge was so trusting of Denny, he allowed Denny as the only person in that courtroom, no member of the public, no other journalists, to listen to the proceedings and report on him, because he trusted him not to identify him. So that's a kind of a extreme example of how much he was trusted. There he was by himself in the courtroom.
And the secret docketing, I'd never heard of that before.
Yeah.
Where they would file these cases and they would not stamp the records and put them in a file, and they were kind of being handled under the table.
Right, so that was the Nathanson case with the California Coastal Commission. And Nathanson was convicted of several felonies for taking bribes from developers who are trying to get fancy houses approved by the Coastal Commission. And he's convicted, but he's got information he thinks that the government can use. And if he gives them that information, then they should file a Rule 35 motion to reduce his sentence based on the helpful information he's provided to the government. Well, the government doesn't file that motion. He serves a year, and so Nathanson files his own motion. We find this out later. Rule 35 is filed only by the government, not by the defendant, but in this case, he filed his own Rule 35 motion. He had 2 letters attached to it, so that's 3 documents, the motion and 2 what we call proffer letters that were attached. We didn't know that they existed until another 6 months or so later. The prosecutor does file a Rule 35 motion, and it says that Nathanson's sentence should be reduced by a year because of some kind of skin condition he has, like humanitarian, which is not Rule 35. That's supposed to be assistance to the government. So they don't want to actually get into what these documents, but they feel like we're going to reduce his sentence by a year. Well, that's a lot to reduce your sentence by. So Denny goes looking and notices that there's a 3-document break in the list and the numbers for the documents. So documents 178, 179, 180 are missing, and then they start over at 181 and continue. So where are these 3 documents? And it turned out later we found out they'd been locked in a safe where Denny couldn't get a hold of them. So we intervened. The court allowed us to intervene in the case to get a hold of these documents. Judge Carlton didn't want us to see them. He knew what was in these documents. He thought they would hurt the reputations of private individuals and a public official it may be completely baseless what this Nathanson was saying. Of course, he's a convicted felon, so we're not going to disclose them. So we take a case to the Ninth Circuit, and the Ninth Circuit looks at it and says, no, you've got to disclose these documents, and orders Judge Carlton to disclose the documents to us, whatever reputation injury to a public official and private individuals dealing with the Coastal Commission. No, that's not something that would keep the public from knowing what's in these documents. So Judge Carlton says, oh, fine. So here's the motion. And then he redacts all the names out of the letters. So we go up to the Court of Appeal again. It was a kind of a funny situation. The well-known public official's attorney appeared as a doe rather than identify himself, so that as though we couldn't actually know who he was or who he represented. We did, but he appears as a John Doe attorney, and he's arguing to Judge Noonan of the Ninth Circuit that we don't know who it is, and these reputations could be harmed and all that. And Judge Noonan basically says, no, wait, I ordered you to disclose these documents. I want you to disclose them. And so we went back, and Judge Carlton had to do it. It was kind of a funny case because we knew who the official was. Judge Carlton knew who the official was. He was trying to, like, don't you get it? We're trying to protect this person. I was like, don't you get it? We're the Sacramento Bee. We're actually going to show what's going on in your courtroom. So we got it. But that's, putting things in a safe and locking it. But then Denny, don't do that to somebody like Denny, because he can count. There's 3 documents missing from this docket.
You can't say who they were protecting?
It was Governor Gray Davis.
Really?
Mm-hmm.
Wow.
He was accused of soliciting campaign contributions. So, we'll help you with Nathanson. I'll help you with the Coastal Mission. You give a campaign contribution to Gray Davis.
I'm curious, did you meet any challenges as a female attorney throughout that time, or it didn't matter at that point?
Looking back, I think the fact that I was in Sacramento, where there were lots of women in government attorney positions, so women going into court, it was not as, I didn't really realize it so much at the time. And then I was the governor for this district of California women lawyers and go into little counties around here, and there were no women practicing law. So I think a huge advantage for me was they were used to seeing women, accomplished women, working for state government in attorneys' offices. You'd go in and they would think you were going to be the stenographer, that kind of thing, but you could deal with that. I do remember the first time I appeared before a woman judge where the only person who was a male in the room was the criminal defendant. So all the judges, all the attorneys, the deputy, the sheriff's deputy, the clerk, attorney for the Bee, everybody was a woman, and this one poor guy's like, whoa, what happened here? So that was unusual.
Yeah, that's interesting, though.
Yeah.
How about you as a female reporter? Did you ever?
Well, I started reporting in the late 1970s. I graduated in '76 from college, but I worked all the time I was in college. I worked as a reporter, and there were many times where you run into that, and you just have to deal with it when it happens. I remember one time, years ago. I'm thinking this fall. I was maybe still in college. I was covering a protest, a strike at a coal mine, and these guys found out I was a reporter, and they were going to take my camera from me. And I got up on a tree stump, and I held my camera up, and I said, "Anybody comes near me, and I'm going to yell rape."
Yeah.
Yeah. But I think women in the newsroom, by the 70s and late 70s and early 80s were much more common, and you just had to deal with it when it came along.
So do you think, as an attorney, you talked about different things that the Bee was instrumental in changing laws here in California?
Yeah.
You talked about the SHIELD law and so forth.
Well, this whole juvenile court 827, that was Nancy. Getting that interpreted first time that the court had done it.
And the secret docketing.
The secret docketing, yeah. That wasn't a decision that was precedent, but it changed how courts operated. They knew Denny would find out they were doing it, and I think they stopped it. And a lot of the things actually, as I say, were resolved by improvements to statutes, so that the kinds of things we had to go through on our defamation and invasion of privacy cases, once you get the slap. I'm sure the fact that we were in Sacramento and could editorialize and talk to the California Newspaper Publishers Association and support things like the anti-SLAPP motion to strike were very helpful. And that's in large part because McClatchy was doing the work, but they were also here and working with Capitol and supporting the California Newspaper Publishers Association.
Also the pretrial, getting pretrial hearings open.
Yeah.
That was pretty substantial. I think that's an important impact you had on the law.
Well, here, yeah, I mean, except the Riverside Press beat me to the Supreme Court, so, oh well.
But you got quoted in Life magazine.
All right.
Yeah.
I was on CNN once. That was, Scott Peterson. There's so much. I was on CNN, and a guy in my office comes in the next day. He was subletting an office. He goes, Charity, you wouldn't believe it. There's this woman, this attorney on CNN. She looked exactly like you. She had all your mannerisms. And it's like, yes, that was me. People couldn't believe it. But
You would go on TV or?
that I was on. They were just recording in the courtroom. I didn't agree to go on separately because I didn't want this to be a media circus. But
It was a media circus.
it was a media circus. Yes.
Still is. I mean,
Yeah.
he's
Well,
trying to get a retrial.
Mark Garagos he'll make anything into a circus. Oh, he was swearing up Blue Streak when he called me up. Like, I'm not going to listen to this. What are you thinking? I'm got a phone. I can put it down. And,
What was he yelling at you about?
oh, I don't know, because we were trying to get a hold of records and so on.
What about the Unabomber case? That was an interesting
Oh,
case. with,
Unabomber, yeah, that was that was an anonymous jury, and Judge Burrell decided that he would allow the jurors to be selected without making public their names, and we objected because at the same time the Waco case was going on, and that was more of a cult, and there were a lot of people associated with this cult, and there was maybe some more legitimate concern that somebody might be tampering with the jury or threatening people. And Judge Burrell, and we found out later, and the judge of the Waco case were talking to each other because another friend of mine who's a media lawyer in Colorado was representing the press in the Waco case. So we figured out they're changing. No, so I was like, this is not Waco. This Unabomber is a loner. He has no friends. That was the whole point of this thing. So there's no reason for this jury to be anonymous. And so we took that case up to the Ninth Circuit. But that was where the internet was just starting to be more of a concern. And Judge Kozinski, he's like, you don't know what kind of wackos out there are going to be watching this. So he was not persuaded, but Judge Burrell was persuaded that he was not going to do anything, and he became very, very good judge about protecting rights of access. So anybody want to do a little side hearing in chambers, nope, we're not going to do that. We're going to sit here where the public can hear. If the jury has to go, we'll send them out. Not going to file any documents under seal. So he just became, and forever after, was very, very observant of these rights. So again, it's making that investment, educating the judges paid off.
Well, the important thing about the jury names is that you want a jury of your peers, and you don't want to have a jury of your friends. And so that's why it's important. But I think the news media has been very restrained about how we use the names.
Yeah, there's no reason. Yeah. But the point is, and it happens, somebody watching a jury and, wow, that woman's the sister of the district attorney, that kind of thing. So you want them to be open, and the transparency serves the purpose of protecting the process. Well, it's interesting that the Bee did really support in-depth investigative reporting.
Yes.
It wasn't.
And they stood behind us. I remember I had, I think, 5 members of the city council. I can't remember how many came in. I was telling Charity this. It might have been a violation of the Brown Act. Came in and complained to Rick Rodriguez about a series I wrote about neighborhoods that had the most crime rates using kind of, at that point, new data, computer data. And You know, just, I never felt that, I knew I was never going to be stood up. That they were always going to be behind my back on any case that was filed against me, and that's a big confidence to know that the newspaper has your back, your editor has your back.
Yeah.
Yeah.
That is.
And the Bee, McClatchy and the Bee always did. I mean, they were upright people.
Mm-hmm.